So I got Tony Naro with me today. Thanks for coming on, Tony.
Happy to be here. Thanks for having me.
So Attorney Naro is a very experienced criminal defense attorney in New Hampshire. We have worked together on many different cases. Tony, one of the subjects that comes up a lot is that we represent people in white-collar criminal defense cases, but New England's being so small, they can be facing multiple charges in different states. So what happens when I'm dealing with someone in Boston federal court, but they also have something up in New Hampshire? What kind of can happen in those situations?
That is, it's becoming more and more common. For me, the biggest thing that I do, I call the federal attorney immediately. That's, as a state practitioner, that's my first move. If it's a public defense case, I'm calling the federal defender. They're fantastic. If you're representing them, lucky them. I'm calling you. And I'm taking the lead. I'm taking the lead from the federal defense attorney. And I think that's important for state practitioners to know, because you might think you're doing a great thing for your client in state court. Hey, I got this great deal. We're going to plead you in, get you out. Yes. And guess what? You just caused some havoc on their life. You might have, pushed them into another class in terms of sentencing, right? You just gave them another criminal history point without even knowing it. Now they might even be looking at a consecutive sentence now. Right. The feds aren't going to run the sentence concurrent with the state. So you got to, as a state practitioner, first thing you do, you get on the horn with the federal defense attorney.
Yeah, so let's break that down kind of one by one. Let's assume the person's out of custody. That's the easier scenario that we can touch upon first. So say if I have a guy in federal court, he could take a minor sentence wherever it may be, but he also has something to deal with in state court. So a lot of times here, depending on what county you are, a lot of state courts will kind of let the federal court sentence happen, and they may just kind of get rid of the state court case. But what happens in New Hampshire? Say if they're also facing something up there, but they're going to take I want to say substantial, but take a federal prison sentence, and who knows where they're going to be shipped to. We're getting a lot of guys getting sent to like Brooklyn or New York. I mean, it could technically be anywhere in the United States, but they're generally staying in New England. What is New Hampshire judges doing in those situations? Are they getting rid of the case? Are they giving them on and after time? What's happening in those situations?
Yeah, so, in the times of COVID, thankfully, if you have, let's say, a misdemeanor sentence, you're going to be able to do, in most courts right now, a plea by mail. Now, is that practice going to continue? Hard to say. I would hope that if it's good for COVID, it'll be good when my client gets shipped to serve in Dallas, right? And we're not going to be able to get them. Are there going to be video capabilities? Potentially. And so you could potentially do a video plea. There's really no easy answer. In New Hampshire, we are somewhat fortunate because there's Stratford County House Corrections in Dover, where there are federal inmates held. Though those are generally immigration and pre-trial detainees. But then we have Berlin. And so they are local to a degree. And so that can kind of take out some of the complications. I've always just tried to communicate again with the federal defense attorney and the U.S. attorney who's assigned to the case to work out those logistics ahead of time. And I would say for the most part, judges in New Hampshire and most prosecutors are understanding. I mean, the last thing a prosecutor wants to do, for the most part, is have this cluster where, hey, we have a deal worked out, but now the guy is in another jurisdiction and we're not going to be able to have him in here. And if we do, it's not free. And so if your client gets a substantial sentence in federal, court, I think more times than not, you're able to get the state prosecutor to back off a little bit. Okay. It depends on the nature of the charge, right? If it's a rape case,
right,
forget about it, right?
Right. No,
but if it's a dinky misdemeanor or a theft where there can be some restitution, I think that you can generally work things out. But you have to think ahead of time. You got to plan ahead.
Yeah, and I think that's when we coordinate a lot, because not only can they get charged in federal court in Massachusetts, they can also get charged in state court for fraud, or for something in New England. Every state may want to bring charges so they can also find them, right? Or also bring a civil suit against the corporation. So that happens a lot. All right, are you ready for a little mental gymnastics here? because this is gonna be interesting.
I am ready. Let's do this.
All right. So say if a person,
I got my pen and I got my legal notepad out. I got the long one. So let's do this.
These are always interesting situations. So say if a person's held in custody, okay, they aren't being held in New Hampshire. They have a New Hampshire state case. They have a federal case also in Massachusetts. Say they're being held in, I don't know, Connecticut. All right. So obviously there's a couple ways for them to come back to Massachusetts, right? They can either waive extradition or then go through the whole extradition. That could be one way of dealing with it. But if they don't decide to bring him back, now we got the whole IAD issue. So the interstate detention or agreement detainer system, which is super complicated. So where we've seen it happen in Massachusetts is if maybe they waived extradition, but they're not going to pick them up, right? Connecticut's probably not that much of an issue, but I've had clients, I'm sure you had clients in Texas, in California, they don't want to pick them up. So now they got the IAD, they got a certain amount of time to try to resolve their cases. What are you seeing happen in New Hampshire when they're on the 180-day clock?
So, I mean, first of all, I mean, and it's important for state practitioners to realize, hey, if your client doesn't waive extradition for a mass case, they're going to be losing their pretrial credit. New Hampshire, not the case. So if you have a case in New Hampshire and you fight extradition, you're gonna. I've always gotten pretrial credit, and I believe the SJC has said no in Massachusetts under the same circumstances. So if you're in New Hampshire and you fight it going back to Mass, you're not going to get that time when you were fighting it.
That's correct.
For me, and so for me, when I have the 180-day clock ticking. And it looks like they're not going to make it. I'm quiet as a mouse, Jason. I'm quiet as a mouse.
Very smart.
Of course, it's all about client-centered representation, right? So if my client is in Connecticut and saying, Tony, I want to get up there. I don't want to sit. I'm not getting through my programming. This is really jamming me up. And it's not just the 180 days, because then you're going to have to file a motion to dismiss. We're going to have to get a hearing date. Correct. What if they want me up there for that? Then I'm still not up there. And honestly, man, just get me up there, ride them. That's what I'm going to do. If that's the client's informed choice, I'm going to do that. But otherwise, I'm going to tell my client, listen, I'm not going to beg the government to prosecute you. And if they don't want to prosecute you, they have the notice. Now, when you're dealing with IAD, there's a checklist, right? So you got to make sure everything's been perfected, service has been perfected, everybody has received it, and I've had situations where it was not, your clients generally with the IAD, they're doing it pro se, right? They're doing it from the jail, they're doing it from the prison, and prison officials are guiding them sometimes, and the case managers are guiding them, and they do it incorrectly. So when you get an IAD case, the first thing you need to do, you need to say, all right, I'm the attorney on the case. Did I do this right? Pretend you're the one that did this paperwork. Are you happy with what it looks like? And if not, fix it, because there's nothing worse than waiting for 6 months and then going back and checking and saying, oh, geez, you don't have a motion to dismiss. And you just sat for nothing, and that doesn't fly.
And that's a really important point, because you need to make sure the notice is correct, right? And I don't think most people understand that it starts with the prison, it starts with the superintendent and the sheriff's office, and then the notice then is supposed to go through the office to the law enforcement or the prosecuting body, whoever that is. So there's a lot of notice requirements in terms of what stage of the process they need to do, what actually is included in the petition. And if it's incorrect, that's a problem, right? They're going to say that's not appropriate. Now, what we bumped into in Massachusetts is that they have that out clause to say in extraordinary circumstances, right? So that is not very clear about what that is. And during certain times, say, well, because the case is so complicated that it needs more time to be prosecuted, which is really not within the IAD. If you look in the policies, really thought of.
No. And I always, my response to that is, well, if your case is that complicated to prosecute, well, you indicted it in 2019. It's 2021. Right. What was your plan in 2019? To delay the case inevitably, or were you going to try the case you indicted? So if they have the time and the wherewithal and the information and the capacity to indict your client, they better have that same capacity to try them and there's speedy trial deadlines as well. So they gotta be ready to go.
Even though they're somewhat frozen for us in terms of the speedy trials right now. And it's been a mess, but the SJC has ruled a couple times. It's completely fine. So we're going to see what the new round does. The other thing I want to also talk about is also you have to figure out, even though physically your client may be in a particular prison in a holding area, it's important to figure out who actually has authority over their body, right? If they're in DOC custody, or if they're in state custody, or the sheriff or the county's custody, it's very different in terms of when we argue should they be getting credit. Because if they're not in DOC custody, now I'm going to federal court, it's going to be a lot trickier. And vice versa, if they're in DOC custody or NICE custody, and you're trying to argue they should get credit for that in New Hampshire State Court, I assume, I don't know, but that could be also trickier for you. So you need to be very clear in terms of like who actually has the authority to be holding them in that location.
And I'll tell you, Jason, I recently had a case on appeal, a young man who was going to be extradited back to China. And he did not get a stand committed sentence on his at trial. And on appeal, it had nothing to do with the sentence. But he did have some time hanging over his head. He had 12 months hanging over his head. And before he could voluntarily remove himself after his trial, ICE picked him up, held him in Stratford County. And I was able, and he was held for over a year while the appeal was pending. And I was able to negotiate with the county attorney to say, listen, you know, he's held because of this case. He's going to be extradited. You know, we're probably not going to win the appeal given the issues. Can we just go back and give him some pretrial credit for the time he spent at Stratford County because of the conviction? And they agreed in that instance. Now, are you going to be able to do that every time? No, but I mean, that's why, you know, you hire me, because I have the relationship. I have a lot of relationships with prosecutors. If they don't know you, they're not going to give you the time. Correct. If I'm coming to them and I say, listen, you know, don't be a jerk to my client, you know, you can get some headway. But yeah, so I've been able to do that in the past, but you know, most of the time, yeah, they're just doing dead time, and it's terrible.
Oh, you know? It's brutal. It's absolutely brutal. And that's what we're talking about in terms of coordination, to make sure they're not doing on and after time. They're not doing dead time for the feds. They're not doing dead time for the state. Granted, yes, they made a mistake, maybe a huge mistake in their life, and they you know, maybe prison is the correct punishment for them. But I don't think either judge envisioned that they don't know how the sentence is going to be executed. So that is something that we can certainly try to make as fair as possible, so that everyone's on the same page. The judge knows what they're actually sentencing them to. But there's generally very little coordination on the federal and state level in terms of trying to coordinate that.
Yeah, and you know, one of the things that I have always done too is when I have a client charged, especially with reciprocal crimes, so they're charged for essentially the same conduct, state level and federal level, is, you know, to coordinate and say to the, you know, the U.S. attorney, hey, if they're convicted here first, are you going to still prosecute their case? And sometimes the answer is no. So there is that policy document, and I don't know how they're applying it in Boston, but in New Hampshire, they've been fairly consistent that if there is a state conviction, they will not move forward with the federal case except in certain circumstances. And so there's that memorandum that's floating out there. And, you know, if you have a child pornography case, that memo may not apply. But if you have a drug possession or drug sale case and it's a limited quantities, we're not dealing in kilos, you know, you might be able to negotiate something ahead of time and avoid the federal prosecution. But you need to be damn sure before you enter that plea in state court.
Well, that's exactly it. I mean, I've had success in the past pre-charge, and that's why hiring you or I very early in the process is very important, because they have a lot of control in terms of what they want to do with the case pre-indictment. But after indictment, there's, you know, that they got to run it through a committee, they got to talk to the supervisor, and it just becomes very complicated. Hello.
My nanny, she's getting the baby monitor.
No problem. But yeah, it's really important to talk to the U.S. Attorney's Office at the pre-charge stage, because I've had some success moving some cases from the federal level to the state, where the guidelines, well, even the federal guidelines aren't required, but they're followed much more closely. The state really doesn't have guidelines at this point. And the sentences are much looser, right? So you can do that pre-charge, but if you're going to wait to hire an attorney after indictment, it's going to be a lot harder. There's still stuff that we can do, but your options are much more limited.
Yeah. Once you're indicted by the feds, usually that is going to be it. It's going to be very hard to walk that back. And that's why I was saying to you the other week, sometimes the greatest gift the government can give you is a target letter. And because you can go and get counsel. If you can't afford counsel, you can go down to the federal district court and apply for counsel and get a federal public defender. And they're all fantastic attorneys. So even if you don't have resources, you're still going to be okay. And it's a great thing. And then you can coordinate with your state attorney if there is a state case, or they can reach out and get state counsel and start to talk to the DA or the county attorney if you're in New Hampshire, and start working something out. But there are a lot of pitfalls. And the other thing too is, I learned early in my career, if your client has a federal record and they're on probation, they get arrested for something state level. Maybe it's something small, like an operating after suspension, possession of a little bit of cocaine, not a big deal. Hey, no violation was filed in federal court yet. That's not the end of it. You got to call their former federal attorney, and you got to talk to them and say, listen, this is what's going on. What's a conviction going to do? Because they will violate you. Correct. The day you plead guilty to that offense, they're going to violate you in federal court, and you have some significant exposure potentially. And so you can't just think, oh, well, hey, they didn't file a violation of probation, they must not care about that. No, they're lying in wait. And I think that's critical for state practitioners to understand as well. Don't ever assume anything.
No, and pretty much every sentence now has supervised release, a mandatory term that comes with it, and it's really strict and stringent, and it's not like state court probation. It's very different in terms of the rules and the violations, and it can lead to very serious consequences. But Tony, I mean, obviously you're my go-to guy with anything in New Hampshire. Can you tell a little bit about the people who are watching?
Appreciate that.
When they should call you. Like, what types of cases should they call you? I know you don't, even though you have a ton of experience with IEDs, and it's a really complicated area, but you also practice a lot of other criminal law. So when should people call you? Yeah.
Right. If you are charged with a criminal offense in the state of New Hampshire, it's a state level offense, you need to call me. DWIs particularly, don't wait until your arraignment date. I'm talking the day after. And if it's a weekend, you email me. My email is easy, tony@bernazanilaw.com, right? And you can just Google me, Tony Naro. It's going to come right up. But you want to call the day after, because there is a lot that can happen in the early stages of a case that do not happen if you just kind of wait to say, well, I'm not sure if I'm going to hire somebody, or maybe I'll get a public defender. I'll just see what happens at the arraignment. Maybe the prosecutor will make me an offer. Nobody's looking to do you any favors in court. And the only person that you can trust when you're charged is your defense attorney. Same thing with, domestic violence offenses, Jason. Sometimes people get charged with DV and they wait and see what happens when they get to court, and they say, well, I'll call my attorney, a week or two before I have court, and I'll hire somebody then.
What a mistake.
It's sooner the better. The sooner the better. You got to do it right away. And I always tell people, you get out of jail, the first thing you do is you email me or you call my office, leave me a message. I work 7 days. You know this, right? I work 7 days a week. I'm on, and usually with the family time from 5 to 9 when the kids go to bed, and at 9 o'clock I fire the computer back up because people's lives and liberty are at risk here. And, we can't rest. Government doesn't rest, neither should your defense, right?
That's great, Tony. So thanks for coming on, and hope to see you again soon.
Yeah. Thanks for having me.